So you want to learn how to protect your digital products from copycats. Today, we're going to talk about different ways you can legally protect your digital products without hiring a lawyer. Hi, I'm Michelle. I'm a business attorney and I've helped many online business owners put legal protections in place, namely through my digital product usage agreement that we will talk about later to prevent their content from being stolen and sold online. First, let's start with copyright protection, a vital aspect for anyone creating a digital product. I'll break this down into different areas to give you a comprehensive understanding of copyright. So you may be wondering, what is copyright? It's a form of protection provided by the laws of the US and other countries to the authors of original works of authorship. And this includes not only books or articles, but things like music, artwork, and yes, your digital products like courses and templates. So when you create something original and fix it into a tangible form, like your course, it's automatically protected by copyright. This protection lasts for your lifetime plus an additional 70 years. Now, while your work is automatically protected from the moment of creation, you should think about registering it with the Copyright Office. Why? Because registered works are public records. They provide a clear trail of ownership. And if you ever need to take someone to court for copyright infringement, it allows you to claim statutory damages and recover attorney's fees. So how do you register your copyright? You would just fill out an application form on the US Copyright Office website. You'll pay a fee and you'll submit a copy of your work. And this process can be done entirely online. If you have something simple like a book published by yourself and nobody else, then I recommend, doing it yourself. But if you have joint creations or you're just not confident in doing it yourself, hire an attorney. Additionally, it's smart to add a copyright notice to your digital products. This is a simple statement that typically includes the copyright symbol, the year of first publication, and your name or the name of your company. And this notice acts as a warning against unauthorized use, and it's a visible claim of your ownership. It's not legally required, but it is a best practice so that you can deter infringement and demonstrate your intent to protect your rights. Now, what happens if someone infringes on your copyright? You have several options. You can, of course, send a cease and desist letter, which is just a formal request to stop the unauthorized use. If you find your work on a website or a social media platform, you can file a DMCA takedown notice with the host of the platform. So, if you use GoDaddy or if you find something on Instagram, you would go directly to them. And if that doesn't work, you might need to escalate to legal action. And remember, to sue for copyright infringement in federal court, you'll have to have a registered copyright with the US Copyright Office. So let's focus on a critical aspect of protecting your digital products, and that is licensing agreements. And these agreements are legally binding contracts that specify how your content can be used, who can use it, and under what conditions. Let's talk about what to include in your licensing agreement and a unique clause that I include in mine that can offer you additional protection. A licensing agreement should clearly define the scope and the limits of how your digital product can be used. This includes specifying whether the license is for personal or commercial use, and any restrictions that you want to impose. It's also essential to define the duration of the license. So is it one-time use? Is it a lifetime license? You would also want to think about whether it is an exclusive license or is it non-exclusive. So you have the flexibility to tailor this agreement to fit the nature of your digital product. And you can include your licensing agreement in various places to make sure it is seen by your purchasers. So you can add it to your terms of use. You can put it on a separate page on your website. You can also include it inside of your digital products. If you have a course platform that somebody has to log into to get access to the products, you can add it inside of that as well. So in addition, that you can make to your licensing agreement is a section that requires someone to agree to pay a settlement if they are found sharing or using your license improperly. They'll lose access to the content and they must pay a settlement fee to regain the license back. This not only serves as a deterrent to unauthorized sharing, but also provides a clear, predefined path for resolution if there is some type of infringement that occurs. And this clause also gives you the opportunity to seek other legal actions if necessary. And at this point in the video, you may be wondering more about how to create this licensing agreement with the settlement offer included. And I've already done that for you inside of the legal edit, which includes the digital product usage agreement to prevent someone from stealing your content inside of your digital product, plus 2 other templates that help prevent being fined by the FTC. Just click the link in my description box or in the comment section to learn more. So moving on to the next critical topic, terms of use. This is where you lay down the law for how your digital products can be used. It's more than just fine print. It is a crucial tool for protecting your intellectual property. So let's break this down into parts to understand why it's essential and what they should include. Why are your terms of use so important? They are legally binding agreements between you and the users of your digital products, and these terms set out clear expectations and rules, reducing misunderstandings and misuse. They are your first line of defense in protecting your intellectual property and ensuring that your content is used in the way you intended it to. So here are some things that you should be including in your terms of use. First, the scope of use. Clearly define how your product can be used. Can it be modified? Can they share parts of the content? If they give credit to you, like, you can put all of that inside of the scope of use. Your intellectual property clause. This states that you retain all rights of your content, and it should cover copyright details, usage rights, and any limitations. Your user responsibilities. Outline what is expected of users, including compliance with laws and regulations. And then you'll want a limitation of liability clause. And these just limit your liability in case any issues arise from the use of your product. And you'll also want to have a termination clause, so just specify under what circumstances a user's access to your product may be revoked. And you want your terms to be thorough, but also understandable to non-lawyers, so you'll want to just avoid overly complex legal jargon. Also, remember, your terms of use aren't set in stone. As your business evolves, your terms of use are also going to evolve. So regularly review and update them to reflect new products, services, or legal requirements. And when changes are made, make sure that you're communicating them clearly to your users. And this keeps everyone on the same page and ensures ongoing protection for your work. Now, let's turn our attention to a very practical aspect of protecting your digital products, and that is watermarks. These are often associated with images, but they can be used in a variety of digital formats. A watermark is a logo, a text, or pattern that's superimposed onto your product, and it makes it difficult to use or copy without authorization. It's usually semi-transparent, ensuring that it doesn't interfere too much with the user's experience, but it is still noticeable. Watermarks are especially popular among photographers, graphic designers, and digital artists as a way to protect their visual content. And while watermarks are a valuable tool, they do have limitations. So if you have a more sophisticated user, they might find a way to remove them, especially if they're not expertly integrated. And so that this is why watermarks should just be a broader part of a strategy to protect your digital content, along with like other legal things that we were talking about earlier, like the copyright notices, the licensing agreements, etc. So for your video courses, watermarks serve as a constant reminder of your ownership, and again, it deters unauthorized distribution. So you can place a watermark in the corner of your video so that it's not disrupting the viewing experience. And you'll also want to make sure that your watermark is consistent in all your videos for uniformity. Now, if you sell ebooks or document templates, like those created in Google Docs or Word, you can also add a watermark to establish ownership. And your ebooks can like be in PDF form or whatever format that you choose. But you're going to want to make sure that any watermark is light and unobtrusive so that it doesn't interfere with the readability or usability of the template. Now let's talk about another effective strategy to protect your digital products, and that's using expiring links. And this is particularly useful for items like downloadable courses, ebooks, or templates. An expiring link is just an extra layer of control over who accesses your content and for how long. So expiring links are essentially URLs that provide access to your digital product for a limited time. After a set period, that link becomes inactive, preventing further downloads or access. And so this time-sensitive feature is a great way to control distribution and prevent unauthorized sharing. If you want to implement expiring links, many e-commerce platforms and digital product management system, content management systems have already built that in as an option. I use ThriveCart and Shopify. I know for a fact ThriveCart does have expiring links, and I'm sure Shopify has an app that does the same. So you'll want to set a reasonable time frame for the link to remain active. This could be 24 hours, a few days, whatever makes sense for your product. And the most important part about this is having clear communication with your customer. Inform the customer about the expiration time frame right from the start. This can be included in your purchase confirmation email, a note during the download process, on your sales page, on your product description page. You could also add it to your terms of use, because normally they will have to agree to the terms of use before they actually purchase your product. So it's just really important that your users are aware and agree to these conditions before they purchase. Now, if you're someone who wants to learn more about legally protecting their online business, watch my next video where I'll cover how to protect your personal assets from paying business debts when you are the owner of an LLC. I'll see you over there.